going to be doing the case over Gebser versus Lago Vista Independent School District. You can find this on Chapter 8.4, page 274. While in the spring semester in 1991, Alida Starr Gebser was an 8th grade student at Lago Vista Middle School. She joined a high school book discussion club that was led by Lago Vista High School teacher Frank Waldrop. During this book club, Waldrop regularly made sexual comments to the students that were in attendance at these book discussion meetings. Gebser later went into her freshman year of high school and had classes in both of her freshman year semesters that were taught by Waldrop. Throughout those semesters, Waldrop kept making continuous sexual comments to the students in each class and started to make direct comments towards Gebser when they were alone in the classroom at ample amount of times. While coming to her home in the spring to give her a book for the book club, he initiated sexual contact with her. The two ended up having sexual relations on a number of occasions during her freshman year school year. Their relationship continued into the summer, and they continued to have sexual relations into the following school year, which would have been her sophomore year. At this time, the Lago Vista School District had no policy or procedure when sexual harassment occurred, and that is required by federal law to have. Gebser never reported anything to the school officials about the sexual relationship with her and Waldrop because even though she knew that what was going on was an improper case of conduct, she never knew how to react and did not want him to be fired from his teaching job. In the fall semester of October 1992, the parents of two other students in those classes made complaints to the principal of the high school about the comments that Waldrop had been making in the classes. The principal ended up having a meeting involving the principal, Waldrop, and the parents. Waldrop ended up stating that he did not make any of these sexual comments to students, and he also apologized to the parents in attendance, where he also mentioned he would never have these comments happen again if they happened even before. The principal never reported these complaints made by the parents of the superintendent to the school, which the superintendent was the school district's Title IX coordinator. In January 1993, Waldrop and Gebser were caught by a police officer while having one of their sexual encounters, and the officer therefore arrested Waldrop on the spot. Waldrop was then terminated of his employment by Lago Vista, and the Texas Education Agency took away his teaching license as well. In November 1993, Gebser and her mother filed a suit against Lago Vista Independent School District and Frank Waldrop in the state court. They claimed that Gebser she was harassed in violation of Title IX of the Education Amendments Act of 1972. Gebser and her mother, they sought out compensatory and punitive damages from both Lago Vista and Waldrop. The suit that was put on Lago Vista and Waldrop from Gebser and her mother ended up being dropped, while the U.S. District Court for the Western District of Texas, they granted a summary judgment for Lago Vista and all of the claims against them, and therefore the allegations were remanded against Waldrop as well. There was not enough evidence that to raise an issue against the district because the only complaints that they had were the one-time complaints by the parents of the students. Gebser and her mother appealed for the court to uphold by reaffirming that the school district was not liable for the teacher and student sexual relationship under the Title IX amendment. In the end, the final ruling of the court was in favor of Lago Vista due to the fact that two minimal criteria had to be met in order to recover sexual harassment damages under Title IX. The first one was the plaintiff must show that a school official knew about the forbidden conduct. The second one was despite knowing of the forbidden conduct, the school district failed to respond in the proper way. Lago Vista never knew of the relationship, which in granted made Lago Vista not liable of the sexual harassment damages. As an athletic director, understanding everything that is entitled with this Title IX amendment and make sure that all the things covered in it are happening in the right way, going the right direction in the athletic program. This will keep away any lawsuits such as this. Having these policies and procedures for sexual harassment incidents have to be put in place. Understanding that the coaches and anything involved in athletic staff do being put in place, the federal law. Even though this case is only with a student and teacher, an athletic director can still be notified by a student athlete that's involved in some kind of sexual harassment way with anyone in the school district. That'll be all for this case.